Well, hello, folks. This is the man behind the mirror going to do a short read. Hope you enjoy. This topic's going to be on Unconstitutional Act. So, there we go. The court follows the decision of the highest court in the state in construing the Constitution and the laws of the state unless they conflict with or impair the efficiency of some principle of the Constitution or of the federal statutes, a rule of the commercial or general law. The decision of the state courts and questions relating to the existence of its subordinate tribunals and the eligibility of election or appointment of their officers and the passage of its laws are conclusive upon federal courts. Now, the most important thing is, while acts of de facto incumbent, can't even pronounce it very good, incumbent, INCUMBENT, of an office lawfully created by law, an existing or often held to be binding from reasons of public policy. That's very, very confused with the state's rights of eminent domain of police powers. Police powers and public policy are almost the same thing, except that one is done without law because they want to, and the other is done because they are claiming a police authority to do so. So, what comes to mind to me is you have policies versus police powers. Now, there's a distinctive difference. And they kind of utilize the police policies as actual law, and they're not really actual law. They're regulations, statutes, codes, and most likely, most of them are in conflict with the Constitution, your contract. Now, police powers is powers delegated to them all the way back up from a state level and federal level, but it actually comes from the executive powers, which the executive authority is the sword of the government as the whole union, the compact agreement of the constitutions in harmony. The power actually comes from the authority of the executive branch of the separations of powers. But however, if you go deep back into history, the state originated before the actual union when it was formed with the Constitution. Each state before was a sovereign state, and they had their own powers delegated from their own, as like a nation themselves. But anyways, police powers is delegated by the 10th Amendment. And again, it comes from the executive branch, separations of powers. So any police officers, when they work for the city, county, or whoever they work for, they're making a promise under oath, an oath of office at a state level and a federal level. That's in harmony. So that's where the police powers come from. So each individual officer, they don't even know this, but under Article 6, Paragraph 2, they're bound to the oath of office under their police powers, and they're dedicated and promised by swearing to protect and preserve the Constitution of the United States of America and at each states of the Union. So that's where they get their power. That's what's delegated. They don't even realize that they have more power actually under police authority and power than the judge and the lawyers. The judge and the lawyers, well, they take the oath too, but they're separations of powers. You got the judicial, but what happens is they team up and they've learned to utilize their powers against the masses, which it was designed to protect the masses and the people. But they flip things around and think that the provisions in the actual contract protects them, and they use it against the people. I laugh because that's what they do. But the contract is for the people, and the contract is basically the judge, the lawyers, and the police officers' limitations under the authority which is delegated to them from the branches of government. So that's that on that. I hope you understand a little bit about that, how I broke it down. But basically, there's a distinctive difference between police policies and police powers. Excuse me. Let's see. When they are talking about public policy, the acts of the person assuming to fill and perform the duties of an office which does not exist can have no validity whatever in law. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protections. Creates no office, and is in legal contemplation as inoperative as though it had never been passed. So what they do is those police policies, they're treating them like laws. And their police policies are actually obstructing. It's actually in conflict with their limitations. So they're overreaching further of their delegated power, their authority, way overreach. They're not complying to it the way they're supposed to, their limitations. Okay. However, now if you take these basic cases that we have gone over so far, you will have gone a long way in getting your constitutional rights. This book, Citizen Handbook, includes the Constitution, jury instructions, arguments, and a lot more. Some of the important arguments in it go along with what I've been talking about. Let's see. All laws which are repugnant to the Constitution are null and void. That key word, repugnant. Repugnant falls into encroachment and infringement because that's how they do it, the repugnant here. So, and what backs that up is this most famous case here I always talk about is called Marbury versus Madison, 5 U.S. 137. And that's basically stating any secondary law that's in conflict with your actual law. And any part, any clause, if it's in conflict, it's repugnant, it's void and null, and no state is bound to it, no delegated authority is bound to it, no office is bound to it, no institution is bound to it. It's automatically void and null. And you really don't even have to go to court to claim it. All you got to do is, they try to drag you in there, but I'm going to get into detail of that. Because when they drag you in there, you're complying to an unconstitutional contract. But you don't want to comply. You don't want to consent to their contract. You want to claim your contract. So these overreach, you can reflect them down against the latter and keep them at bound and bay that won't be utilized against you if you know how to apply it. Where rights secured by the Constitution are involved, there can be no rule or law-making legislation which would abrogate, abolish them. So any actual laws that are in conflict, they can't make other laws and legislative fiat and making other laws that are in conflict with the provisions, amendments, and Declaration of Rights. As in different states, they say Declaration of Rights or Bill of Rights or provisions or amendments. And there's another case law that backs it up. There's actually 3 or 4 of these Miranda versus Arizona cases, but this one listed here is the Miranda versus Arizona cases is anytime an officer suspects you of a crime or you commit a crime in front of an officer, he has to read your rights to you immediately before he arrest you or put the cuffs on you. Or he could put the cuffs on you and read the Miranda rights. But a lot of times, anytime they're going to make an arrest, they have to, by law, read you the Miranda rights. And that case is called Miranda versus Arizona, 384 U.S. 436. Okay. An unconstitutional act is not law. It confers no rights, it imposes no duties, it affords no protections, it creates no office. It is in legal contemplation as inoperative as though it had never been passed. And there's another law that backs it up. You ready? It's called Norton versus Shelby County, 118 U.S. 425. Now, these laws and these case laws are all supreme laws that I'm giving you. You need to look them up and read the merits of it, because if you ever find yourself in court and the judge asks you any of the merits of those cases, which I really highly doubt if they do, because the judges ain't smart enough to even know the merits of these cases. There is a few out there that are, but most of them don't. They just look at it and then you plug it in and they look. I really believe that they use a lot of case laws they plug in and they don't even really not in parallel or in correlation, and the merits doesn't even have anything to do with the actual situation. I believe that from just some of the readings of responses that I got from judges and lawyers and. But anyways. The general rule is that an unconstitutional statute, though having the form and name of law, in reality no law. Did you hear that? Get that? That's amazing. See, if you don't know, it's what they say it is. So I'm going to advise you, to the peasants, to the poor, to the American people, whatever name you have, you need to know. Because if you don't know, you're going to be a slave. You're not going to be the master, or you're going to be the slave. And that's the way the system's designed from all these foreign institutions that come here and dock their ships and bring you into their ships. And when you can shut them down with your own contract of the land as a common person, private person at that. Okay, so here's some 16 Amateur Volume 2, Section 177 and 256. This is a lawyer cases that are report cases that are filed and saved. There's like over 200 of them. But anyways, in 16th Amateur Juror Volume 2, Section 177, 256, officers of courts have no immunity from liability when violating constitutional rights. So 16th Amateur tells you right there, they can't diminish your rights, they can't steal your rights, they can't take them away. It's nice to know that 16th Amateur volumes, those are actual constitutional law. I believe the attorneys get maybe 2 semesters of that actual law before they go in and specialize in their taxation, their divorce, their criminal, and whatever their admiralty, merchant commerce, and all these other different statute courts and code courts. But the one you want to know is the Constitution courts, your court, and you own the court by we being the people, we the people. Okay, so officers of the court have no immunity from liability when violating constitutional rights. And there's a couple other case laws I can give you that you, and under Title 42 U.S., you can sue them for violating your rights for, I don't know, $50,000 per violation, $10,000 per violation, whatever you think feel fit to it. But I mean, I wouldn't get greedy, just, you know. Okay, so here's the other couple of cases that lock that in that you can utilize if you're going to sue them for violating your rights. Owen versus City of Independence, 445 U.S. 622, and Maine versus Thibodeau, 448 U.S. 1. Outstanding. It says, no state shall convert secured liberties into privileges and issue a license and fee for it. Okay, here's a case law, supreme law, called Murdoch versus Pennsylvania, 319 U.S. 105. If the state does not convert your liberty into a privilege, you can engage. It says if the state does convert your liberty into a privilege, you can engage in that right with impunity. So you have a right to claim impunity when they throw all these unconstitutional acts, statutes, codes, and regulations. Put it on the record, file it, and make sure the judge, the cop, and attorneys are obeying Article 6, Paragraph 2, the oath of office. The case that backs that up, again, for if the state does convert your liberty into a privilege any way, it's called Shuttlesworth versus City of Burlingame, Alabama, 373 U.S. 262. And if I remember right, that case has got something to do with segregation back in the 60s when some bishops or pastors went into a white restaurant and did a demonstration against in the white restaurant for segregation back then. I believe that's in the merits of that case. It's Shuttlesworth versus City of Burlingame. The court is to protect against any encroachment of constitutional securities. Case law that backs that one up is Boyd versus United States, 116 U.S. 616. Constitutional rights must be interpreted in favor of the citizen. You're the citizen, you and I, were the claim beneficiary. Just remember, you're the beneficiary of the Constitution. Then you can claim. But you have to do it in writing. You can't do it by just rapping your mouth off and arguing with the police officer on the side of the road. You're going to have to follow the program going and play the game and fight it. Okay, that case law to back it up for that is called Briers versus United States, 273 U.S. 28. Okay? We have covered all these cases thoroughly so that you can see clearly in the Citizens Rule Book, or these case laws, the jury has the right to judge both the laws as well as the facts. Okay, John J., First Chief Justice of the Supreme Court. The jury has the right to determine both the law and the facts. Samuel Chase, Supreme Court Justice. The jury has the power to bring in verdict in the teeth of the both law and fact. Oliver Wendell Holmes, U.S. Supreme Court. The law itself is on trial quite as much as the cause which is to be decided. Harlan F. Stone, Chief Justice of the Supreme Court. The pages of history shine on instances of juries exercise of its prerogative to disregard the instructions of the judge. And it gives a case law followed behind that. United States versus Daugherty, 473 FED 2nd 113. Okay, so I'm going to leave with that, and I'm going to close by saying thank you for listening, and I enjoy reading these, reading the discovery, and I will sign off now. The man behind the mirror. God bless you.